Thank you, Alok, for this accommodation. And I must especially thank Brother Justice Lokur also for giving me this precedence. He should have spoken first. I had mentioned to Prashant that I had a commitment at 11, so I may have to go at 11, but I definitely would like to listen to Justice Madan also before I go. So straight to the topic, both of us were also Chief Justices in the High Courts. Sister Anjana is also there, Sister Nega is also there. So all of us know how the High Courts function. Under Article 229, the Chief Justice is the supreme as far as the High Court is concerned. There also, the High Court functions through committees. The most important committee is the Administrative Committee. Then comes various other committees. But I do not find such a system of functioning of the Supreme Court. Though we have a few committees, I don't think the Supreme Court actually functions through its committees. Why I mention this at the outset is because Supreme Court is always regarded, considered and conceived as the guardian of the Constitution of India, the High Courts. As the given this name, Chief Justice of India, is not unlike the High Courts. The High Court Justice of the High Court of a particular state. But coming to, in fact, I went through the Constitutional Assembly debates on this Karta. Though he takes, that's very interesting, he takes oath, his appointment is as Chief Justice of India, I've seen the warrants. But coming to the oath under the third schedule, oath is as Chief Justice, when I made an outright robust observation that this is judicial indiscipline, where a two-judge bench declining to follow a three-judge bench. And then a judge who is the two-judge makes an observation, goes to the three and presides over the five. I don't know how this system works. What is the special interest of a judge in a case? Because a judge, when he takes oath, his oath is different even from the oath of the President of India. The judge's oath is he will uphold the Constitution and the laws. He's not upholding anything else. I've seen judges speaking, I've done my best according to my conscience. He has no special conscience, individual conscience. His conscience is only the constitutional conscience. He does not have a conscience formed either by his ideology or by his philosophy or by the commitment of the patrons who have helped him to reach that position. His conscience is the conscience of the Constitution. He is the conscience keeper of the Constitution. Therefore, whatever he does only to uphold the Constitution. Well, when we had that press conference, which we have not disclosed so far, I don't think that anybody has told thereafter also. We had a series of meetings thereafter. At least for 2 weeks, those meetings continued. And those meetings were of all the incoming Chief Justices with these four of us. And there was one suggestion that the master of roster exercise should be appropriately regulated, not controlled, appropriately regulated in order to avoid a perceived arbitrariness. I refuse to believe that any Chief Justice is arbitrary. But there is a perception, and nobody can blame for that perception also. the first main observation I made after my retirement also is that there is a perception of a remote control in the Supreme Court. So there is a perception in the minds of the public that the master of roaster business is not handled the way it should be handled. So the general discussion was that there could be some regulation that at least the first three could be the master of roaster committee. I'm aware that there was a PIL filed by our renowned Mr. Shantibhushan for 5. But 5 may be a little difficult. According to me, at least the first 3. And I'm sure of the first 3, at least one would be an incumbent for the next coming post of incoming Chief Justice. The first 3, if 3 of them could sit and then take a call on the listing of cases, on the constitution of the quorum, on the subject allocation to judges, and in a given situation, what to do when a judge recuses. These are the 4 situations the master of roaster has to handle an issue sensitively, though it is now become sensational. It is sensational because its constitutional sensitivity is not actually considered the way it should have been considered, because there is a perception. And you can blame the people for having that perception because that is what is actually heard even from inside. Though we went outside and spoke, there is a new trend of people inside and talking at least. But I don't know all these things are going to, whether they are being listened to, they're going to deaf ears, I believe. So my first suggestion on that master of roaster business is that, it should be done at least by a 3. And on the constitution of the benches, particularly very important constitutional matters, the diversity should be reflected. Regional, gender, at least these 2 should be reflected in constituting the benches. It should not be left to a person to select 4 or 5 people, 4 or 5 judges and constitute a bench. As I told in the beginning, it's not very difficult to get a decision if you know the mindset of a judge. Though there is a presumption that the judge doesn't have a particular mindset, the judge has only a constitutional mindset because the judge exercises his duties without fear, favor, affection or ill will. On the lighter side, is that perception correct now? Just I'm asking. I'm talking to a few lawyers. They were just quibbling something. In Supreme Court, it's a well-known thing that, the advocates and record know. They will not choose a senior till they know of the constitution of the bench. After seeing the constitution, they will go for an appropriate senior for the bench. That's known to everybody. But now the trend is not that. Now the trend is, if the case is posted before a bench, people are able to predict what the result is, what the outcome is. That has become the shift in the trend now. So people don't mind, in fact spend money in getting seniors because result is fairly well known. If it is before A bench, this is the result. On B subject. This is actually the perception people have. I'm not speaking my considered view, but I'm saying I'm only airing the perception of the people, of the stakeholders, who are mainly the lawyers practicing in the Supreme Court. Because since we continue in our own way as arbitrators and mediators and consultants, a lot of lawyers appear before us and they also share some of their concerns. So this is these are my two considered suggestions. Just coming with that, I would also like to add, because this is a very important occasion, though it's not the audience that matters, but this program that matters. In all other high courts and the national institutions, the motto is Satyameva Jayate. But our Supreme Court has a different motto. Our Supreme Court's motto is Yado Dharma Stado Jaya. I don't know why that different motto is adopted by the Supreme Court of India. Because to me, for the Supreme Court, the guardian of the Constitution, truth is the Constitution. Dharma is not always the truth. Dharma is discharge of your duty in terms of the need of the hour. That is Dharma as popularly understood. So I would request the Chief Justice of India and the well-meaning companions with him and also the public to think about this issue as to why the Supreme Court should have a different motto, different from the national motto, because that makes a lot of difference in its approach. On this subject in the afternoon, which unfortunately I'm not able to participate, there is also a perception that the constitutional courts forget about the second part of Article 21. They think and interpret Article 21 only as a right to life and forget the rest part of it, which is the best part of it, and personal liberty. And what is life without liberty? Why should there be life without liberty? If you are taking away the liberty part of a person, there's no point in giving him the life part of his life. So I think I'm of the strong view that our constitutional courts should keep in mind this Article 21 should be understood giving equal importance to both aspects of life and liberty. But the perception now is that life is of course guarded, but liberty is ignored. And finally, on the whistleblowers aspect also, we are not able to find many whistleblowers. We were just spending 5 minutes before the conference tea. We discussed quite a few things. But all those things which we discussed, do we read in any media? Do we see in any electronic media? Except a couple of private media in the digital side, we do not find any fearless, truthful version of the facts coming out. The greatest blow to democracy is that the fourth pillar has failed the country. Forget about the first three pillars. Fourth pillar is the media. They have failed to defend democracy. They have failed to defend the Constitution.